So I'd like to take a moment to introduce our keynote speaker, Adam Cordover. He will be coming on in just a moment for a presentation on all the ways to collaborate, examining different models of collaborative practice. Adam B. Cordover is a collaborative lawyer and Florida Supreme Court certified family law mediator. He is a member of the board of the International Academy of Collaborative Professionals, the IACP, as some of you may know it, and recipient of the inaugural Florida Academy of Collaborative Professionals, FACP. Visionary Award for founding and co-instructing the FACP Leadership Institute. He is co-author with Forrest Woody Mostyn of Building a Successful Collaborative Family Law Practice, published by the American Bar Association in 2018. Adam is a former president of Next Generation Divorce in Tampa Bay and Greater Sarasota, growing it to become the largest collaborative practice group in North America. In 2015, Adam stopped taking litigation cases and now practices exclusively in out-of-court dispute resolution. Adam is currently accepting family law matters from throughout the state of Florida and has offices in Tampa, St. Petersburg, and Sarasota. And I will drop Adam's website into the chat if you'd like to learn more. And on that note, I would love to pass things over to you, Adam, to get started with your presentation.
Welcome, Adam. Thank you for joining us today.
Thank you. Thank you so much, Russ. Thank you so much, Shannon, and everybody here at the summit. As Shannon just mentioned, I stopped taking litigation cases back in 2015. And just to put that in a little context, or as I like to say it, I retired from litigation at the ripe old age of 35 years old back in 2015. And I did this so that I could focus on peacemaking work, out-of-court dispute resolution, and really with a focus, a specialty on collaborative practice and collaborative family law. But one issue that I found is that I was limiting myself on the ways that I could offer collaborative practice to clients. And I was limiting the amount of clients that could access the form of collaborative practice that I was providing. And fortunately, there are some role models out there. Ron Oski, former president of the IACP, and one of the original collaborative practitioners, and also friend and mentor Woody Mostyn, who's the father of unbundled legal services. They all had a philosophy that rather than trying to push clients into one particular model of collaborative family law, we professionals have a duty to mold a model of collaborative family law to fit the needs of the clients that are in front of us. And I'll explain a little bit more what I mean by that and offer some different examples throughout this keynote presentation. So I think it's oftentimes helpful to really take a step back and determine what counts as a collaborative practice file. What are the requirements for it to be considered collaborative matter? Because I've learned, especially in working with newly trained professionals, that they have all different ideas. And really, when they think of collaborative practice, they're thinking of a particular model, but not the basics of what is essential, what are the requirements. There really are only 3 essential requirements for a case to be considered a collaborative practice file. Number 1, each person needs to have their own lawyer. Number 2, there needs to be a written participation agreement that lays out the rules of the case and of the way that they're going to proceed. And number 3, there needs to be a disqualification clause that says that in the event that the parties are unable to reach an agreement or otherwise that somebody files a contested pleading, that the lawyers and the other professionals are disqualified from continuing on in the case. So long as you have all 3 of those elements, it is a collaborative practice file. You can put a bunch of different things on top of that, but so long as those 3 main things are there, it's collaborative practice. If any of those 3 things are missing, then it is not a collaborative practice file by definition. So, I hear all the time, is somebody who is a lawyer, well, can I represent myself in a collaborative case? No, you need to have a separate independent lawyer for yourself, as does the other spouse, and have these other elements for it to be considered a collaborative practice matter. So I mentioned models before, and let's talk first with the original model. By the way, I consider myself a little bit of a daredevil, although there are times where I want to kind of She-Hulk out. But I think these are all great role models, if you will. But in the original model of collaborative practice, it was the lawyer-only model of collaborative practice. So this is where each person has their own lawyer. There's a written participation agreement and a disqualification clause, and no other professionals. Back in 1990, when Stu Webb, an attorney in Minneapolis, created the collaborative process, this was the model that he had in mind. And since then, every model that has come since has built on the lawyer-only model. And this is still a model that I use in my practice in certain cases. So for example, if it's a case where it's relatively simple and there are no children, it's a relatively short-term marriage and very few assets and debts, then I might consider doing a lawyer-only model of collaborative practice. Typically, I'll put in my participation agreement that if it's truly should be resolved in a lawyer-only model, we should be able to resolve things within one meeting or within 60 days. And if we can't resolve things within one meeting or within 60 days, then we may bring in another professional. But again, there are clients where this model makes sense, and there are clients that can resolve their matters within 60 days or within one meeting. So that's a lawyer-only model of collaborative practice. The next model of collaborative practice is known as the two-coach model of collaborative practice. This was a model that was established out of California in the United States by Peggy Thompson and Pauline Tesler. Many of you may be familiar with those names. And in this model, the original interdisciplinary model of collaborative practice, each person has their own lawyer. Each person also has an aligned coach or licensed mental health professional. There is oftentimes a neutral financial professional, and many times there's a neutral child specialist. And the child specialist is there to bring on the voice of the children into the case. And so this is not the model that I was originally taught. And so it's not a model that is commonly used in my home state of Florida. But I have used this model of collaborative practice in circumstances that warranted it. And so I'll give an example. There was one case that I had where the husband retained me and he wanted to do things collaboratively. He mentioned that his wife was bipolar and had some issues, but even with that going on, he wanted to move forward in a collaborative manner. I sent over a letter which explained the collaborative process and gave the names of some collaborative attorneys. And about a week later, they were still living in the same house. She went through a bipolar manic episode, and she attempted to burn down the door of the bedroom that he was staying in. Now, it doesn't sound like that ought to be a collaborative case, right? And actually, that case I was litigating at the time. I filed a domestic violence injunction, and in the meantime, she actually ended up hiring one of the collaborative attorneys whom I recommended. And me and the other attorney talked, and we first said that we don't know if this can be a collaborative case. But if it is, it probably makes sense for there to be two separate coaches on the case, because given her condition, she probably would not recognize a neutral mental health professional as neutral. But again, we did not know whether this case could go collaborative. So we ended up sending her to a psychological evaluator. And this person was a psychologist. and the evaluator said that, no, this can't be collaborative right now. But if there are some things that are put in place, then it could be. And he said, so long as she starts seeing a psychiatrist and starts getting medication and gets stable housing that is outside of the house, and confirm that, yes, and so long as they're each agreed to have their own aligned coach, that yes, this could be a collaborative case. And so we started this case in pretty much a domestic violence court. Ultimately, the injunction was put in place, but with a provision that the clients could move forward in a collaborative process so long as these steps happened, and so long as those provisions were put in place. Those steps did happen, those provisions were put in place, and we did move forward in a two-coach model of collaborative practice. So we found a model where we needed more support than the typical model that we use, and we utilized that model. So let's go on to the next model of collaborative cases. This is actually the form that I was originally taught. I understand in many parts of Canada that this is the main model that is used as well. It's known as the one coach model, or neutral coach, or neutral facilitator, sometimes also known as the neutral mental health professional model. And in this model, each person has their own lawyer. There is a neutral coach, and oftentimes also a neutral financial professional, and in some cases and in some communities, a neutral child specialist. And this is kind of the basic model that we use. This is I basically use this as a catch-all, a default model, that if there aren't special circumstances that make sense for a different model, this is the model that I use. Okay. And by the way, this gentleman in here, that's Jeremy Gaze. He is my co-trainer and I consider one of the best mental health professionals / facilitators / coaches in the business. Okay, so let's talk about somewhat of a newer model of collaborative practice, which not a whole lot of people have heard of, but it's starting to gain some traction in some communities. It's known as collaborative mediation. And this is basically a combination of mediation practice and collaborative practice. And in this, each person, just like any other case, each person has their own lawyer. There's a written participation agreement that includes a disqualification clause, but there's also a fourth element to this as well, and that is there is one or more mediators who help in the process. And the mediator might be instead of all of the other neutrals that might be in the case, or all of the other professionals, or the mediator might be in addition to other professionals who may be in the case. And I find that there are certain cases where this makes sense. So for example, if a case originates from a mediator, oftentimes a mediator, or most mediators, let clients know that they ought to retain an attorney to review any agreements or possibly to participate in the mediation process. And mediators usually have an incentive to bring in collaborative lawyers because they know if that collaborative lawyers are trained to help parties reach an agreement outside of court, which is a different skill set than helping clients find a resolution within the court system. And if everybody signs a participation agreement that includes a disqualification clause, this makes the attorneys and the mediators and the clients all moving forward on the same page in trying to reach a resolution, and giving the clients the understanding that within the mediation process, that if they don't reach an agreement, that the attorneys will not be used against each other. So again, these are great for cases where the collaborative matter originates from a mediator, or where the clients would prefer to use a mediator who's not a mental health professional, because I think there are some communities that just have some bias against mental health professionals. I don't agree with that, but I also accept that that is the case. And so in those cases, a neutral mediator may be a good fit for that particular family. And one additional model of collaborative practice, and this was coined by Nancy Cameron, who is a friend and a mentor, and she discusses the Lego model of collaborative practice. And so again, this starts out the same way as every other case, that each person has their own lawyer. There's a written participation agreement that includes a disqualification clause, and the spouses retain really any other professional that may be helpful for the entire process or discrete tasks within the process. And let me provide some examples. It may be that the parents just want to bring in a child specialist for the limited purpose. If there's a troubled teen, for example, and they just want to have at least one meeting with the teen just to make sure they're okay, they may retain a child specialist for the limited purpose of that one meeting. Or maybe that they need to bring on a real estate professional to get a real estate appraisal or some other works. Or I've had cases where we've needed to bring in an estate planning lawyer. That may be where the clients are older. They want to figure out what are the trusts and other documents that they may need to help fashion the particular agreement for them. Other cases may require a vocational evaluator, somebody to help determine what skill sets, what experience does somebody have, and what amount of money that they can make for purposes of determining an alimony amount. I've discussed psychological evaluator, and there are business valuations, substance abuse evaluators, all sorts of different building blocks that you need. And so my purpose, my hope with this keynote address is number one, to help you understand that there's not just one model of collaborative practice, but there are many models of collaborative practice. And it really is incumbent upon us to build the model of collaborative practice that makes sense for the family in front of us, rather than trying to push the clients into the model that we like or we are most comfortable with. And I hope, with all these different models and learning that there's a lot of different ways to do out-of-court dispute resolution, one thing that I learned along the way, and it was really impactful to me, is that there are some people who like to litigate and want to litigate and really, really appreciate that. And I totally respect that. And that's just not me. And I personally don't like being in the litigation mode. So one thing I hope to let you all realize and recognize is that if you don't want to litigate, you don't have to. There are options. You just have to think about what are the different options that you're going to offer. And just so you know, as I mentioned, I stopped litigating in 2015, and my business has grown from there. And in the last 2 years, I basically doubled my revenue. So you don't have to litigate, and you can still be profitable. So I just want to mention as well, in some final points, you can find out more about the way that I view things, as well as my mentor and co-author, Woody Mostyn, Forrest Mostyn, in building a successful collaborative family law practice. I believe digital copies are still available at the American Bar Association website, and you can find the link in the PowerPoint, which I believe was provided to you. And here's my contact information. I've got offices in Tampa, St. Petersburg, and Sarasota, but I represent clients virtually throughout the state of Florida. So if you know somebody who could use our services in Florida, please, we'll take care of them. We invite you to send them our way. And so with that, Shannon, I just want to check to see if there are any questions or anything I can answer or help with.
All right, thank you so much, Adam. Again, we appreciate you being here so much and sharing your vast knowledge of collaborative practice. It's very much appreciated. I'm just gonna quickly have a look at the Q&A. I don't have any. Russ, did you have any questions or comments?
It's great seeing you again, Adam. It's been a while since the IACP, but I deeply appreciate all the work you've done for collaborative practice, the IACP, and also sharing your thoughts with our audience today. It's been fantastic.
Russ, thank you so much. I'm so impressed with the summit that you and your team have put together, and for such a great cause. So, so excellent, and it was an honor.
Thank you so much.